Hey friends, welcome to part 2 in my series on how to get a green card despite the fact that you've overstayed your visa. If you have not yet caught part 1, go back, watch it. I'm going to put a link to it here, and then also watch upcoming videos that I'm going to do on this subject. For those of you who are new to me, welcome to my channel. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients all over the US and in many different countries. If you have an immigration matter that you need assistance with, contact us. We'd be happy to take a look at it for you and see how we might be able to help you. Let's get into it. As I said in my first video, or part 1, this series is directed specifically for those of you who were inspected by customs. You had a visa and you entered. You were allowed in. In part 1, we talked about getting a green card through a U.S. citizen spouse. In this video, we're going to talk about getting the green card through a U.S. citizen child. Who is a child, right? We're going to get into that shortly. But getting the green card through your U.S. citizen child will allow you to adjust your status so that you may be able to get your green card right here in the United States. While you're waiting for the green card application to be processed, you'll be eligible for the employment authorization document. You'll get a social security card, and you could also get a travel document. What is really required here to prove that you're eligible for a green card through your child? Well, the first thing is this. The child must be an adult child, at least 21 years old, and that child must also be a U.S. citizen. The next requirement is where it really gets complicated very quickly for some people, and we work on these matters. What I'm going to share with you in this video are really examples from the types of cases that we've worked on at McBean Law. But the other thing that you must prove is the relationship, the parent-child relationship. And in some cases, it's as easy as just submitting the birth certificate and that's that. But in other cases, you must also prove that you've been in the child's life or you've supported that child. If you're not able to accomplish these basic things, then it's possible for the petition to be denied. Now, your case can get complicated if any of the following things is going on in your case. Firstly, if the birth certificate was obtained years after the child was born. If that did happen, the U.S. government will question the relationship. Secondly, if the parent and child didn't live together, right? They weren't living together while the child was growing up. That can become an issue as well, particularly for fathers who were not in the child's life during the time the child was growing up. They typically face a harder time proving this parental relationship. What I will say related to this problem is if a child was born out of wedlock, then the government will look to a primary piece of evidence to prove that that parent was in the child's life. So, for example, they're going to want some sort of proof of custody that was obtained when the child was under the age of 18. Specifically, a written document saying that that's your child, right? Aside from the birth certificate, they're going to want something additional for parents in this situation. And so we're talking about something like a court order, like a child support order. And if that doesn't exist, then the government has a list of additional evidence that they're looking to called secondary evidence to show that you've been there for the child, such as proof of payment and other records, some sort of paper trail along the way to show that you were really in that child's life. The other way that this can get complicated, obviously, is if the parent's name is not on the child's birth certificate. I did mention, not living together, but if the parent or child are living in different cities or countries, you're going to have to go deeper and prove that parental relationship. The other way that this gets very complicated for some people is if the parent has some sort of violation that requires a waiver, an inadmissibility problem. And inadmissibility problems, as you guys have heard me talk about before, are problems around fraud or misrepresentation. Perhaps the parent had years ago submitted an immigration application, right? Benefit application, maybe LULAC or an I-360 petition alleging all sorts of things that were not true. And that's on the parent's record right now. Well, or if the parent has some sort of criminal record or any other inadmissibility problems, that parent will need a waiver. And so if that parent is not able to get the waiver approved, the green card application would also not be approved. There are 3 ways in which the child-parent petition will never work. I mean, never work, okay? So you really don't want to be in any of these 3 scenarios that I'm about to discuss. The first is if the parent has marriage fraud on his or her record. If they do have marriage fraud on their record, their immigration record, then they're barred from pursuing a green card before USCIS. So that's a huge problem. Secondly, if the child petitioner is a registered sex offender, then that child is automatically disqualified from petitioning for the parent. And now the third way that the child-parent petition process will never work involves, again, the waiver, the I-601 waiver. If the parent needs that waiver, but that parent doesn't have a qualifying relative for the waiver, then the green card application cannot be approved either. And the qualifying relative that's needed for the I-601 waiver, it's either a U.S. citizen or green card holder parent or spouse, U.S. citizen or green card holder. As you can see, this process is really not that simple for some people. Again, we work at McBean Law on many of the scenarios that I described earlier. So if you find yourself in one of those scenarios, contact us. We're here for you. Have us take a look at where things are at, whether it's a previous denial through your child, or whether you have been hesitant about having your child petition for you because of the circumstances that I discussed earlier. Let us take a look at it for you and see how we might be able to assist you. If you have not yet subscribed to McBean Immigration TV, go ahead and subscribe and also hit the notification bell so that you'll be the first to get notice of my videos as they come out each week. Thanks so much for watching, and I will see you guys in the next one. Bye-bye.